And if anyone you can't hear me, everyone can hear me okay? Yeah? Okay. Someone just messaged they can't hear me. It is your end. That was my first Zoom semester, and we weren't sure to do testing, and we weren't even sure how the online testing works. So I basically cut the exam in half. Keep in mind, this was a pass-fail semester where nothing counted. So the exam that semester was only one question, way too easy. And I'll be frank, people did really bad because they didn't study. It was a pass-fail. It was like the worst decision we've ever made as a school. I hated it so much. But basically, the entire semester students have no grades for a semester. It was insane. But you know, those are the times. So the actual final is usually twice that length. It's 2 questions in 3 hours. This one's only 90 minutes. So please try and take that exam as soon as you can, at least before Wednesday. What else? One other thing. I am looking for a research assistant starting this summer. That is basically once finals over. And if it works for you and me and both continue to the fall and maybe the spring. I always give people the option. They're not required to, but if it works out well for both of us, it's agreeable. I've done this before with my property students and my first year students. The time commitment, probably 5 to 10 hours a week. The school maxes the work study, the paid work study, I think 20. I very rarely will ever actually have 20 hours of work. So average 5 to 10, give or take. What are you going to work on? Lots of things. Probably a lot of citation, blue booking, which is perhaps not the funnest activity, but it's very important. If you have attention to detail, that's good. If you're interested, please, as soon as you can. I'm not hiring one before the end of the semester, but the next week or two, if you could just send me your resume, your transcript, and maybe a writing sample. Your LRW is fine. Your final project, and I'll happy to take a look, and I'll be just deciding probably during the finals period. But if you can do it before the final period begins, I will be grateful. Okay. Okay. Any questions on the schedule going forward or the RA position or anything else? Oh, I didn't turn the attendance on. I'm sorry. No one reminded me. Usually people are flipping out about that by now. I guess the last day no one cares anymore about attendance. It's true. Okay, the attendance should be going starting now. All right. Any other questions? No? Okay. All right. Well, let's then start with a poll question. I'll give you the class notes are over here. Let's see how you guys do with this question. A little tricky because there are a few moving parts here. All right. So question number 1. It involves a landlord-tenant case and withholding of rent. Okay, so here's the question. The landlord gives tenant a 1-year lease for an apartment. Pay attention. What kind of lease is this? Think about it. The rent is set for $1,000 per month. And we learn that the fair rental value of the apartment is $1,200 per month. The tenant asks the landlord if he can exit the lease 1 month early. That is after the 11th month concludes. Landlord says nothing, doesn't give affirmative consent. Okay, then the tenant vacates. We learn that the landlord spends $100 in advertising. So even though he didn't consent, he obviously started putting the unit back in the market. And the day after the tenant moves out, surprise, surprise, there's a rental for $800 a month. Okay, how much does the tenant owe the landlord? Nothing. $200, $400, $500, $1,000. So you guys do with this one. This one's a little tricky. Okay. Who am I up to next? Who's next on the list?
It's me.
Hello, Onya. Good to see you. All right, my friend. Oh wow, we got a range of answers in this one. Everyone put A, B, C, D. We got all over the place. All right. Now walking through here, Onya, let's just do this one step at a time. What kind of lease is this? How would we characterize this lease?
So this would be a term of years.
Okay. Is it periodic?
Yes, because it's 1 year to 1 year.
Oh no. What's the difference between term of years and periodic?
Hold on, I have to pull mine.
Yeah. You can see how testing this issue is tricky because it involves like 3-4 different topics, which is why I think a lot of you are having some time. What's the difference between a term of years and a year to year?
So term of years would be a fixed period of time.
Uh-huh. And what about periodic?
And the periodic is, it continues until the tenant gives notice.
Okay.
Continue for a succeeding period.
Okay, so what do we have here? Is it a term of years or periodic?
This would be a term of years because they have the intent to end it within 1 year.
What language in this question tells you it's a term of years? What's the giveaway?
That it's a 1 year lease.
Instead
of like year to year or month to month.
That's it. What would I have to say to make it a periodic tenancy? What words would I have to use?
You would have to say year to year.
Okay, very good. All right, thanks, Wendy. Very good. That's good. Number one. So the first thing to keep in mind is what kind of lease you have. If I say a 1 year lease, bells should go off in your head saying, okay, this is term of years, right? Term of years is not periodic tenancy. All right. Nicholas, you here? No. Raymond, you here?
Yep.
Okay, Raymond, so let me ask you the second question. With the term of years, is there any requirement to give advance notice to vacate?
No, only because he wants to leave early.
No, I think you're answering a different question. Is it possible to end a term of years early?
No.
When must the term of year lease end in this case?
After the 12th month.
Okay. So what's the effect of giving notice 1 month early?
Breaching.
I'm sorry?
It would be a breach.
It's a breach. Does that get him off the hook for the last month rent by giving him 1 month notice?
No.
Okay, so now with a periodic tenancy, let's say you have a month-to-month lease, and you give notice 1 month early. Does that get you out of the lease?
It does, but not until the following.
Well, you have 1 full month notice. You give in the first of the month, you give notice. Does that get you out of the lease?
Yes.
Okay, good. So everyone keep this in mind for your notes, right? With a month-to-month lease, you're required to give 1 period notice, right? Which is usually a full month, a full calendar month, as we said. So if you give notice in the first of the month, you're off the hook the next month, right? You're out. But we're not dealing here with the periodic month-to-month lease. We're dealing with the term of years. So the effect of this 1 month notice is irrelevant, right? There's always going to be rent due for the final month, the 12th month, which in this case is $1,000. Okay. Okay. Thanks, Raymond. Matthew here. I think you're in the classroom. Yeah, I see you got your hand up. All right. So Matthew, let me ask you this question, please. He exits a month early, and the very next day, a new tenant walks in and pays $800 a month for rent. Okay. We also know that the landlord spent $100 in advertising. How much does a tenant here owe the landlord?
Does the tenant owe the landlord? I think he would still owe him $1,000 because that's what the month. Because even though he advertised it because he advertised everything, it's not. I guess.
Well, keep in mind. Let's just say he moves out on January 1st, and then on January 2nd, the new tenant moves in, right? the landlord made $800 for the month of January rent.
So I believe the landlord has the duties to mitigate, and that's what he did here.
Right. So can he
so-
charge the full $1,000 if he made $800 from the new tenant? Is that fair?
It's not fair, but I think he can do that though.
So it's basically, isn't that unjust enrichment that you're getting paid twice for the same apartment?
Oh, I guess you're right. Yeah, that would be unjust enrichment.
You can't get paid twice for the same service, can you? So maybe you want to think again what your answer is?
So I'm gonna go. Well, so I put 200, but then that's why I think it was 1,000. But I guess it's right, 200.
So how'd you get to 200? What's your math? Just say it aloud.
1,000 minus 800.
1,000 minus 800. Okay. What about the $100 on advertising?
I just think that's the duty that's the landlord's duty to mitigate.
Cost of doing business, right?
Yeah, cost of doing business.
Not exactly. Okay, thank you, Matt. James, you here?
Yes, sir.
What'd you put here, James?
I'm sorry, do it now.
What did you put here?
I did choose B, but after hearing that's obviously not right, I'm guessing that is D.
How do you get to D? 500. How do you get to that answer?
I was thinking more of like, because the fair value is 1,200.
Oh.
Yeah, and so he spent like $100 on it, and so he's already down $100, and then 800. And so like, so then you take the 800. Now you're down to 700, right? Because he spent 100, and so now he owes him 500 to get back up to the 1,200.
All right, let me just walk through your math for a second, right? Why are you starting with the fair market value of 1,200 and not the rental price of 1,000? Why are you using one number versus the other to start with?
To be honest, I'm not entirely sure. It's just whenever there's a fair value, I usually go with that.
You're right. You're actually right. Your instinct after 2 semesters of law school is correct, right? The relevant number here is not 1,000, it's 1,200, right? When we're calculating damages for landlord, we look not just to what the rental value is, but what the fair market value is, right? Because maybe, maybe the landlord gave the tenant a lease, when the market was much slower, right? It was a much, cooler market, right? And the past year, the market's really picked up. In theory, the day the tenant moves out, the landlord could have found a lease for $1,200, right? But he was probably hustling. He was in a hurry because he has an empty unit. He doesn't want to go empty, so he negotiated and gave a good rate to this guy for $800, right? We still presume that he could have gotten $1,200. So then, James, what's 1,200 minus 800?
400.
Okay, 400, right? That's the difference between the actual rental value and what he could have gotten in the market if he wasn't such a tight pinch. And then what do we add to that $400 for the to round it out?
His $100 on advertisement.
Which is how much total? $500. That's right. So the answer is D. Almost all of you got this one wrong. Fascinating. I know that this is a hard question, but Zach is here, and I'll get to you in a minute, I promise. Okay. But the idea here is twofold. One, the landlord is going to be compensated for his marketing costs because he had to go and advertise this on short notice, right, to try and figure out to get the unit filled, right? The landlord was put in a tough spot because the tenant vacated early. That's number one. Number two, the tenant can be the hook for the lesser rent, and it's not between 800 and 1,000. Okay, it's between 800 and 1,200. All right. Thank you, James. Very good. That's eventually correct. Zach, go ahead.
Isn't this just basic expectation damages?
Yeah, I guess I didn't think of it that way, but if that's how you want to think about it, sure. I mean, it's what you would have gotten plus your cost of getting the new deal. So yeah, I guess that's right.
Okay, because this new case that we're going to talk about today is the first one to talk about or hint at how to measure damages also.
Yeah.
And they've started to talk about, and what you were saying last time about bringing in the contract precepts into the property working.
Yeah, very good.
Okay, I just want to make sure I'm making the connection. Thank you.
Yeah. I mean, the part of this class that's based on contract doctrine. I'm sorry. The part of this class based on landlord-tenant law is very much contractual. So the things I'm saying will sound familiar from contracts. I said what? Unjust enrichment, right? I said duty to mitigate, expectation damages, right? Fair market value of a widget at a certain date, versus what you actually earned in a pinch. The cost of mitigating damages, there are always costs, right? If you have to negotiate a contract, on the fly, you're not going to get the best deal because you're short on time. So these are all things you probably learn in contracts that are sort of incorporated into property, landlord-tenant property law. That's just sort of how it works. Yeah, but good observation. Bennett, I saw your hand went up. It went down. Are you okay?
I'm fine. I was just wondering why the tenant would be responsible for that $100, but if we're treating it like a contract,
Yeah.
I guess that would be an incidental or consequential loss of the.
Yeah, no, it's a fixed cost, right? Think of it this way, Bennett, right? Let's say the landlord had a tenant lined up to move in January or February, like the next month, right? But he now has a unit sitting vacant and he can't afford to have it vacant. So he says, you know what? I can't have this tenant in February. I need someone earlier to fill the rent right away. And he had to market it very quickly to get there. He would not have incurred that cost but for the early termination, right? It's truly the but for cost of the advertising. Now, practically speaking, he would spend that money in January, February, it doesn't matter. But the fact that he spent that money now is directly attributable to the breach of the tenant.
Okay, that makes sense. I was just saying $100 in this example is fairly reasonable, but I was just thinking if that was $500 or $600, is the tenant really going to be responsible for that? And I guess it would be, you have to make that in good faith. You can't just. Yeah.
Yeah, I think there's probably a reasonableness inquiry. If imagine the landlord signs like a 1 month lease for $100, some ridiculously low amount, and the judge's like, okay, you didn't really mitigate damages. You were just trying to, give a cheap rent to your friend or something, right? You can see a court decide that the mitigation was not reasonable. So I think there's always that on the back end. It's a risk. But here in the question I gave you, it seems like everything was done, as fairly as possible with the few facts I gave you. Make sense?
Awesome. Thank you. Yes, sir. Thank you.
And is my video okay? Someone else messaged that's lagging. I don't see any lag on my side. I have full signal strength. All right. Yeah, maybe the internet's conspiring with us on the last full day of the semester. It's actually much better. Zoom last March was absolutely dreadful because none of our infrastructure was ready for everyone sitting at home on Zoom all day. It just wasn't ready. So signals dropped all the time. This semester I've had what? 2, maybe 3 issues the entire semester. It's been much smoother. Yeah. All right. So the answer here is D. Let me just go through the choices. A bunch of you put 0, which is definitely not right. There's always going to be liability for the tenant by vacating early. Now, imagine I change the facts, right? What if the landlord was paying, the tenant was paying $1,000 a month and the new guy paid $1,500 a month, right? He actually got more. Okay, in that case, it would have been 0 because you can't have unjust enrichment, right? If you're already getting above market rent that covers your costs, you can't go after the tenant, right? You got everything you wanted and more. So if it was above market rate, say $1,500 a month, at that point the tenant's free, right? You can't beat a man while they're down. You can't profit and then get them again. That's an unjust enrichment. I think one of you put, or several of you put 200, which is basically 800 minus 1,000, right? That is starting from the wrong point. We start from the point of the fair market price and not the actual. And just if you're not even sure, if I'm giving you the fair market value in a question, that's a very good signal that I want you to use that number for something, right? I think it was James who said, whenever the question mentions fair market value, use fair market value. that's a pretty good hint, right? I think that's a decent rule of thumb, right? If I'm giving you a number, I want you to use it, right? That I wouldn't give it to you otherwise. I mean, well, maybe I would, but I'm probably giving it to you for some reason. 400 is just a 1,200 minus 800, but you forgot about the advertising costs, which is a fixed cost. And then 1,000, I think that's what Matt initially said, but that would be an unjust enrichment. You're getting the full rent plus the 800 that you got from the new guy, and you can't do that. You can't double dip. All right, everyone get all 5 of those choices? I think this is a good question because it makes you walk through a lot of different steps to get there. It's not just a simple, it took us 20 minutes for one multiple choice question. Hey, Alec, go ahead.
So just a quick clarification. With a term of years lease, you can terminate it early, but you need the express consent of both parties, correct? So notice means nothing, but if the landlord had expressly agreed to terminate early.
Yeah, if both the landlord and tenant consent, it's not just a matter of giving notice, there has to be consent. Parties can always agree to terminate anything early. That's not an issue. Because just think about just logically, the landlord has a reversionary interest. So basically, you're just giving him the sticks back earlier, right? If you consent to it. So both parties have to turn the key in that one. Good? Okay, thanks, Alec. You have a huge headset on. Is that comfortable to wear all class?
It's not so bad. My other headphones died. I usually use the smaller AirPods, but they died. So
Yeah. I don't like the big bulky ones anyway, but it's good. All right. Derek, hey, go ahead. Yeah, I think this question is just one sentence, but I think the failure to respond is in this case is irrelevant because notice doesn't matter, right? If this is a periodic tenancy and you notify your landlord he doesn't respond, that's sufficient, right? There's no obligation for the landlord to respond. But in this one, giving the 1 month notice has zero legal effect. Okay, thank you. Other questions on this one? Okay, great. Oh, Zach, go ahead.
I used the expectation formula to get to the answer once we started figuring it out. But in property law, is there something different? Am I oversimplifying, or is that an adequate way to think about this going forward?
Close enough. I think all I have to say here is you have the fair market value and you have what you actually sold it for, and you have your fixed costs. So that's I guess, is that much different than expectation damages in your mind?
Yeah, I mean, to me, it makes sense to think about it as an expectation formula. I just don't want to get it confused in my head if I see it talked about it.
Yeah, I mean, I wouldn't say expectation damage in the exam. It's not called that, but just if your own head that helps you work it out, that's fine. I don't mind. Okay. But yeah, it's I feel like I'm teaching contracts the last few weeks of the semester. It's just very, very contractual. I mean, after a full semester of fee simple and executory interest and these dreadful things, now it's contracts, right? It's sort of familiar. Okay, but let's go on. This last topic is one that students, especially law students, have the most experience with, which is rent and security deposits. When a landlord gives a lease, he's taking a risk, right? He's letting someone into his home. Okay. Right? He is letting someone into the home to stay there for some extended period of time. And there's no guarantee they actually pay rent, right? So a landlord, is not an idiot. A landlord is a business person. And generally, you don't give credit to someone unless you know you're going to get paid back. So there are different tools at his disposal to collect the rent and to make sure the rent can be paid. Okay. So we're going to talk about some of these remedies. Right. What are the things a landlord can do to take care of these items, right? The most powerful one is called the security deposit, right? A security deposit. This remedy is the most common. I suspect every lease that everyone has ever signed has some security deposit. That amount can fluctuate. When I first moved to Houston, I was actually surprised. I signed a lease. I was in the medical center, and they were like, "Okay, $0 security deposit." Like, wow. I guess they thought I was trustworthy enough. I was a law professor. I wasn't going to run away and destroy the place. Now I had a dog, unfortunately. Oh, this dog she was a lovely dog, but she peed and pooped everywhere. So she destroyed the carpet. So I mean, trust me, I paid on the back end. This was not a freebie. I didn't get off scot-free. They had to replace the entire carpet because my dog was awful with just pie training was not good. But that was a $0 deposit. I've also had a full month of rent for security deposit. Right. Some leases you have to pay 2 full months of rent for security deposit. Right. It varies based on your credit history, who's co-signing with you. There are a lot of factors. Generally, in most jurisdictions, I think that's the rule in Texas, there's a cap of 2 months for security deposit. Now, this part you probably don't know, but the money in your deposit must be put in what's called a trust account. What's a trust account? That money has to be kept separate from the landlord's general bank account. Why? The landlord's not supposed to withdraw from that trust account to cover his expenses. The money that you give the landlord for the security deposit is supposed to stay there in the trust account and earn interest. Who here knew about that? Anyone? Did anyone even know you're supposed to have interest? Yeah, right. I never saw this interest in any apartments I ever had. It's a very small amount, basically close to zero, but there's supposed to be interest being collected. And the idea is you keep the money separate. Why? To make sure the landlord doesn't blow it. Right? Imagine the landlord deposits a security deposit in his general, checking account, and he spends it. And at the end of the lease, there's nothing left. Right? The reason why I have these trust accounts is to prevent the landlord from blowing your money. And it's saved there for the purpose, which is the security department. If any of you worked in law firms or work with attorneys, you've heard the idea of a retainer, right? You've heard that phrase, retainer? A retainer is when you give an attorney money in advance to do some work. And the way it works is you give the lawyer a check, and then as he bills hours, he withdraws from that amount. And if at the end of the engagement there's money left over, the attorney must return the money to you, whatever the balance is. It works the same way. It's a trust account, right? When you give an attorney a retainer, it's a special type of a bank account called a trust account that's separate, that's segregated from the attorney's general funds. The attorney can't, tap the trust account to pay for a new car or a new computer or a new, copy machine, whatever you want to buy, right? The money has to be kept separate. Let me tell you something. The easiest way to lose your law license, right? The easiest way to get disbarred is to co-mingle funds, right? Co-mingle funds. What does that mean? is to use client trust funds to pay for your personal or other business expenses. The client trust funds can only be used to pay for the client matters, right? And you have to be very careful, right? You can only withdraw money from the, John Doe's trust fund to pay for John Doe's legal expenses, right? You can't use Jane Roe's account for John Doe's expenses. That doesn't work. Everything must be kept separately. So really, whenever you have a new client with a retainer, you have to set up a new trust account. And the banks make this easy enough to do. It's not like you have to make an entire new account. The banks know how this works. You just have a new account number, but you keep the funds segregated. And that's really important. I can't stress that enough, right? Right? You have to separate the funds for your clients. And look, I try to make this point at least once per semester. When you become a lawyer, you get a bar journal, right? Now it's all electronic, but every month you get a notice from the Texas bar saying, oh, here are the things going on, right? And if you flip to the back of the journal, there's always a section that says disciplinary, right? Disciplinary actions. And I promise you, every month there's at least one person in the state of Texas who went to this law school. It's all law schools, but we have a lot of lawyers graduate South Texas. But there's always at least one, maybe went to South Texas, that says client fund issues, right? Mismanagement of client funds or commingling funds, right? Because it's just so tempting, right? You have all this money sitting there. You're behind on your bills. Like, oh, let me just borrow from you. I'll put it back next month, right? And then once you do that, you're done, right? Once you borrow from the fund, from the client trust fund, and you fail to put it back, right? Even if you put it back, right? If you borrow it, let's say you have a bill due the first of the month, and then you're getting a check the 15th of the month. Oh, put it back in 2 weeks, right? You're toast, because the client must get what's called an accounting, which is basically a detailed list of what monies were added and subtracted. If the client realizes that you withdrew funds for the wrong purpose, that's an instant bar complaint. And usually bar complaints are hard to litigate because there's a lot of factual disputes. Was there a conflict of interest, right? Did you provide a proper duty of care? Did an attorney work hard enough in a case? Did he do enough research, right? Did he make a bad argument? Those are hard arguments to win on because it's so subjective. But this is not subjective, right? There was $1,000, then there were $900, then there was $1,000 again, right? You took $100 off the top. That's easy, right? That's an easy thing for a bar counsel to find, right? And discipline. Bennett, yeah, it's basically an escrow account. That's exactly what it is. You're putting money held in some neutral entity. The difference, though, is with an escrow, you usually need someone's permission to withdraw. But with a trust account, the attorney can often withdraw without asking the client's permission first, as long as it's pursuant to the agreement. And the reason why is attorneys don't always get paid, right? If you bill by the hour, you may never get the paycheck. Oh, no, one more point. What's the most important rule of lawyering, right? I always ask this question. The most important rule of lawyering. It's not Rule 11, right? It's not Rule 12b-6, right? Let's get paid. If you don't get paid, you don't have a job. You can't keep the lights on. You can't feed your family. Zach, get paid. That's it. So it's sort of like this part of law practice that I always like to flag at this point of the semester, but you got to get paid, right? Attorneys use collection agencies all the time, right? Attorneys require collateral. They can seize assets to pay their bills. It's just another aspect of the job. If you work for the government, your paycheck comes from taxpayers, right? If you work for a big law firm, you don't have to worry about collection. But if you're at a small firm, you have to deal with this. If you're doing criminal and then your guy gets arrested, he doesn't have a lot of money, he has to put up his car for sale, right? It's not a pleasant part of the job, but it's part of the job. Yeah. At landlords. Thanks, James. Okay. So sorry, I apologize for a little bit of a rant on that thing, but I always try to make this point because the trust accounts are very important. And there's supposed to be interest. It's supposed to be interest. I've never seen it, but it's supposed to happen. The idea is if you're giving money to someone to hold on to, right, that's money you could have had yourself that's invested. So that's be some sort of interest. But I guess it's like, pennies. my last apartment before I bought my house, I think I had like $20 left over after all the expenses. They never even sent me a check. They just kept it. So I think there's just rampant abuse in this area. It's not done right. Whatever. I'm not going to sue them over $20, and they knew that. But yeah, when I first moved to the apartment, I was like, oh crap, it was like, oh, we have a brand new carpet. Like, no new carpet. That's bad. The dog's going to destroy it. I want the old crappy carpet. That's what I want. Anyway, my new house is hardwood floors, and my dog passed away. But the idea was we had hardwood floors for at least the beginning. She was a dachshund. She was a good dog. Yeah, she was sweet. I died about 2 years ago. I think 2 years ago this month. I think it was April of 2019. All right. Any questions? Not about my dog, but anything else? All right. One last note on the security deposits. If the landlord actually seeks to withhold from your deposit, they must give you an itemized list of deductions. And this is something that landlords will be happy to do, but they'll overcharge, right? They'll say, oh, we need to fix this, we need to fix that, we need to do this, that, and then it adds up to whatever your deposit is. It was amazing that always, no matter how much your deposit was, the costs were almost exactly that amount. It fills that. You're smiling, right? It's just no matter what your deposit is, that's just about the amount of money that they owe for repairs. Now, landlords try to get around the limitations on deposits by sometimes characterizing deposit as like advance rent, a bonus. One apartment I lived in actually called it a non-refundable deposit. And I was like, that's not a deposit if it's non-refundable. That's a fee or penalty. That was it. They called it a non-refundable pet deposit. I was like, what? That's not a thing. That's a penalty, right? It's just a fine, right? You're charging me without anyway. So they get really creative to try and up the amount of money that they charge for various things. You may have liquidated damages, right? That is something that is permissible, but that has to have a reasonable amount, right? Which are hard to calculate. But if the liquidated damages are too punitive, it can be called a penalty, which again, you learned in contracts, right? If the liquidated damage is too high, the courts won't enforce it. So again, you're seeing contract law, affect it. Has anyone ever had a rent acceleration clause? Anyone ever have one of those? Yeah, I did. When I was living in law school, I had an apartment not too far from the law school, and the landlord wanted a rent acceleration clause, and I didn't really know what that was, so I was reading the lease. Let's say it's a 12-month lease, and let's say in the third month I breach. Immediately, all remaining 9 months of rent come due. Right? The rent accelerates. The entire amount is due. So basically, it's a penalty, right? If you don't pay your rent, you owe the entire amount. Now, the upshot is the landlord can't rent it to someone else to avoid unjust enrichment, right? So in other words, I've just paid 12 months for an apartment that I'm not going to use. It's ridiculous remedy, right? So you're basically paying to keep the unit empty for a year. I never had that. I paid my rent every month, but I remember reading that. I was like, wow, that's pretty severe. I mean, really, I think it was actually a 14-month lease I had signed. You're gonna make me pay 11 months rent if I leave in the third month, just sit there empty. That was the term she had, and I was a dumb student, so I signed it. Okay. Questions on the security deposits or rent acceleration? Yeah, Bennett, go ahead.
For the rent acceleration, is that not giving you giving the landlord ample opportunity to breach that clause? They have it vacant for 11 months, and what if they rent it out to someone during that time?
Well,
are you able to get your money back if that happens?
They can't rent it out. I mean, if they do, I can get the money back. But just think about it for a minute, Bennett. I've just paid for 12 months of rent. That's my unit, right? It would be a trespass for her to rent to someone else. She doesn't have the interest to do it.
Okay.
It's almost like prepaying for 12 months rent in advance as a term of your lease. it really doesn't make sense. I can't. I mean, perhaps in the corporate, like our commercial property, this makes more sense. But in the residential, it was a bizarre thing. I didn't fully understand it when I was a law student, and now I still don't understand it. Many years later. Yeah, Zach, go
Yeah,
ahead.
I feel like that's not the
Oh, I'm sorry, Bennett. I'm sorry to interrupt you. Still
No.
Bennett, then Zach.
I was just saying, I feel like that's not the most efficient way. You should let them try to cover if someone breaches that.
Yeah, or find another tenant or something, right? A sublease, whatever. Yeah, Zach, go ahead.
You went to law school in DC, correct?
Well, Northern Virginia, but right outside of DC, yeah.
Okay, do you think that has something to do with congressional people that might win or lose an election in the middle of their lease?
I never thought about that. Possibly. There was no election that year.
Yeah, if you get a lease in the summertime and you lose in November, what are they gonna do with it?
It's actually very funny. Republicans and Democrats don't agree on much, but they agree on subleases. It's very often that a lot of the outgoing administration sublease apartment to the new administration happens every 4 years or 8 years. I was in law school in 2009 when the administration flipped over. I remember a lot of people were on Craigslist where you had like outgoing Republican, incoming Democrat, taking over an apartment. It happened very frequently. So that's a fair point, Zach. I hadn't thought about that. Aaron, go ahead.
The rent acceleration, is that a kind of thing where it's like assumed you won't pay at all? So it's just putting as much on you as possible with the assumption that you won't. And then
To collect damages and just collect it later?
Yeah. And then
Maybe.
when you inevitably don't, then they can rent it out to someone else.
Right, and that's probably what you expected to happen, that there's no way in hell I'd actually have 12 months rent sitting around. If I did, I would have 1 month rent, right? In other words, if I can't afford 1 month rent, how am I going to afford 11 months rent? Right, it's really kicking man while he's down. And that landlord, she actually did a credit check, had to have verified income. I mean, whatever, it worked out. All right, anything else? All right, let's go on. The next topic is about the duties of a landlord. I used to teach a third-class landlord-tenant. I don't have time this semester because of the Zoom and everything got stretched out. But we have, certain implied warranties, like the implied warranty of habitability. You may see it. We're not talking about implied warranties here. We're talking about express warranties. Often leases will have very precise terms about what a landlord must do and not do. And most leases have language that, they have the duty to maintain the premise in, working condition or working operation. And it's never really clear what that means. And there's often disagreement where the tenant says, oh, do X, Y, and Z to make things better. And the landlord says, nah, things are fine, right? Just wear a mask. Don't worry about the mold. You can imagine saying, just wear a mask. Don't worry about the mold. At common law, you would take the property as is, right? Whatever it is, that's what it is. But starting in the 1960s, the courts began actually much more stringent at the the living conditions of a rental property. So what happens when a conflict arises, right? There's two general types of disputes. In the first dispute, the tenant wants to leave. They just wants to vacate. Vacate means leave. It's like vacation, right? Get out. The tenant wants to vacate, but he decides to stay and pays less rent. Right? So imagine the rent was $1,000 a month, but there's some huge problem. Maybe the windows are broken, right? Maybe there's no heat. He says, you know what? This is not worth $1,000 anymore. I'm going to leave, or I'm going to stay but pay less rent. All right, that's sort of option number one. It was also possible that the tenant sues the landlord and says, okay, you know what? I'm going to stay. I'm going to keep paying my rent, but you owe me damages. Right? Now, the second option requires a lawyer, requires time and effort. The first option is easy, just give them less money. There's more risk to the first option because you might be wrong, and maybe the landlord hasn't breached a lease, in which case you're in the hook for back rent. Okay, with the second one, or with the second proposal, You may get damages, you may not, but at least you won't be on the hook. Okay, any questions so far? Okay. All right, then let's do our case. Marion County, by the way, is in Indianapolis, if you've ever been. Very, very nice town. I like Indianapolis. All right, who am I up to? Natasha, are you here?
Yes, I'm here.
Okay, Natasha, help us out. Give us the facts, please. At least the facts here are actually kind of lengthy, so maybe not all the way, but at least start. I might interrupt you. The facts in Marion County. And it's MCPO, which is a ghastly acronym. It's the Marion County Prosecutor's Office. That's what they keep saying, MCPO. All right, go ahead.
So the plaintiff in this case is also the landlord, and they lease the basement of their building to the MCPO for office and evidence space. And the lease is for 7 years and 5 months starting August 1999. And the lease also states that the landlord will maintain the premises and all the equipment that's used in common with all the tenants. And it includes an exclusive remedy provision, which says that the tenant, in case of a breach, has the right to sue for an injunction or for damages, but they do not have the right to terminate the lease or withhold any rent. And then the property started having water leaks repeatedly every couple of months, which caused substantial damage to the premises, to their evidence boxes, caused molding, and affected some of the employees' health as well.
Okay, good. Let me just pause for a second and just forget about property for a minute. Let's think about criminal law for a minute. This is the prosecutor's office, right, where there's strong evidence from criminal cases. Natasha, what's the effect of destroyed evidence for criminal cases? What does that actually mean? Just pause and think for a minute. What's the consequence of that?
It could destroy the case. They wouldn't be able to prosecute.
Yeah, everyone ever think about that? And thanks, Natasha. I'll give you another anecdote. When I was clerking for a trial judge in Pennsylvania, we had a drug case, and the state police raided a basement. I think it was a meth lab where they were making meth. I think like Breaking Bad, right? They were making meth, and they had all these microwaves and Pyrex dishes, right? And all these scales, right? And all these devices used to make the meth. And I remember the microwave had like just like powder all over it. Like it was just totally, covered in narcotics. So then we get to a trial. The guy was on trial for massive drug production, right? In federal court, with serious charges. He'd be going away for decades. And during the trial, the state detective was on the stand, and the defense lawyer said, how much drugs were there? Where were they? And then the defense lawyer says, so where are all these items? The microwave, the scale, right? The Pyrex dishes, and the detective. Oh, we have photographs of them. And the defense lawyer was like, wait a minute, where are the actual pieces of evidence? And then I'll never forget this. The detective, this look on his face of like, uh-oh, I got caught. And at that point, the federal prosecutor was like, what's going on? So they actually put the jury back into the room to wait. They put the entire trial on hold. It turned out that when the case was transferred from the states to the feds, someone in the evidence room destroyed all the evidence. They just got rid of it. They threw out all the evidence in the case, all the physical evidence, the Pyrex, the microwave, the actual narcotics themselves. They threw everything out. I don't know how this didn't come in pretrial motions. Something got screwed up. I think the U.S. attorney just didn't ask, and the defense attorney wasn't on the game because they had photographs of all the evidence, and they was all right. We have the photographs, and then like an hour later, the prosecutor went to call her boss in Pittsburgh, who was the U.S. attorney, and they came back to the courtroom. This has never happened before in my judge's entire time on the bench. The government dropped all the charges with prejudice. The guy walked out of jail, free man, that day, walked home. He had been in custody for like probably 2 years. And his attorney, if the attorney hadn't asked, where's the evidence, he probably gotten sent to jail for a couple decades. Just anyway, but I always flag the story to stress how important it is to have the actual evidence available. And in this case, when you have a prosecutor's office that has an evidence locker, and like it's getting moldy and destroyed and water damage, and they stay there for a couple of years, right? They don't move the evidence, right? How many cases were potentially ruined that the defendant never even knew about it, right? They just had photographs of the evidence, not the actual evidence. Anyway, I always flag that story to try and just put some context to this case. It's a remarkable case, but like, it's so important to keep physical evidence. And like, look, it's not just when the person's being prosecuted, there are appeals, right? Let's say a conviction is overturned on appeal, you have to do a retrial, right? You can have a conviction overturned and appeal 10 years later. And then the evidence must be kept for all those years in case you need a retrial, right? The murder weapon, right? Tools used to manufacture narcotics, whatever the evidence happens to be. Anyway, crazy story, but yeah, this case always like, oh my God, they're flooding evidence. There could be documents, there could be records, right? There's not electronic evidence, there's paper records. Right? If a piece of paper gets wet, it's destroyed. Right? If you have evidence of some sort of fraud and all you have is the contract, that's destroyed. Anyway, that's what I had in mind when this basement gets flooded all the time. So I guess the rule of thumb is don't put evidence in the basement. Is that the rule of thumb? I suppose. All right. Thanks, Natasha. All right. No, Paul's not here. Azrael, you here?
Yes.
Okay, Azrael. So there are two, I think, relevant dates here that are worth mentioning, right? There are two relevant dates, right? The first date that is relevant is August, right? August 2002. What happened in August 2002 that was really significant?
That was did they decide to leave? Hold on. They met with the IM employee, and they determined that there was an elevated mold count.
Okay. And then what happened that was significant in October of 2002?
I didn't write down all these facts. There's so many.
Yeah, unfortunately, the facts here are important.
There's 4 rooms. They made daily inspections of the leased property, so they were aware of the mold in the evidence room.
What did the landlord tell the tenant about how they should react to the flooding? What sort of advice did they give them, Azrael?
They acknowledged that their evidence was being destroyed.
Yeah, what did they tell them to do?
To store it away from the sort of areas of water damage.
Yeah, put it somewhere else, right?
But the whole place was water damaged, so.
Yeah, but Azrael, what's the significance of the landlord saying, yeah, you probably should keep your evidence in that room, put it somewhere else where there's not damage? What's the significance of that statement?
He acknowledges that there's a problem with it, that there's an issue with storing it there.
And were they being deprived of the use of their property at that point?
Of course, yes.
Okay. One more happened. One more date, Azrael, then you're done. What happened in January of 2003?
They elected to leave.
What was like the last straw? The last straw that happened.
That they owed $380,000 worth of rent.
Well, I know that, but what like pushed them over the edge? Well, what water issue pushed them over the edge?
The major water intrusion into the main evidence room. Stream of water pouring from the ceiling.
Okay, good. All right, thanks, Astral. Yeah, the facts in this one actually are quite important. If you don't have the facts, just check the case summary that's in the shared folder later. So really we have two relevant dates here, right? Three, but really two. One is the October 2002. And at that point, the landlord was like, yeah, we know there's flooding. Maybe don't keep your valuable evidence there, right? At that point, they basically said, yeah, you've rented, however many square feet it was, but you can't use certain parts of it. That's too bad. A landlord can't do that, right? If a landlord rents you, say, 1,000 square feet, that means you should have access to all 1,000 square feet, not just like 950 square feet. And a couple months later, there was this final intrusion of water, and they vacated. They left. Now, Aaron, I saw you here. Aaron, yep.
Yeah.
Aaron, what's the difference between constructive eviction and actual eviction?
Well, actual eviction is when you actually deprive them of occupancy, like you kick them out. Constructive eviction is when you do something or fail to do something that makes it unlivable, makes it essentially you're unable to continue living there.
Okay, so was there a actual eviction in this case?
No.
Is that what the court found?
Oh, wait. No, they found that they had actually and constructively.
Okay, so let's do both. What was the actual eviction in this case, Aaron?
When the landlord sent them that notice to not use parts of the space.
Excellent. Why is that an actual eviction?
Because it's stating that they're not going to fix it, so it's essentially removing them from that part of the.
Yeah, exactly. Very good. An actual eviction doesn't mean you kick them out of the entire property. It's enough to kick them out of part of the property, right? There was this evidence locker and said, yeah, you probably shouldn't use that, right? That statement was pretty dumb, right? It was pretty dumb, but effectively amounted to an eviction from that component of the room, saying, look, yeah, you can't use it, so yeah, go somewhere else. You sign a lease for X square feet. You can't just randomly cut out a part of that. So the actual eviction occurred back in October with the memo to, not use that part of the property. All right, thanks, Aaron. Emily, here, I think I saw you earlier.
Yes, I'm here.
Okay, Emily, help me out. So what's a constructive eviction then?
A constructive eviction occurs when a landlord, by his acts or omissions, does something to make the place uninhabitable. For example, they might cut off the heat or something in the dead of winter. They might, I don't know, they might let the place be overrun with rodents. I don't know.
It's good.
Just is something to make the place uninhabitable.
Yeah, good. I'll ask you in a second. So with constructive eviction, right, you're depriving the tenant of what's called the beneficial use of their property or the part of their property, right? You're depriving the tenant of the beneficial use of part of the property. That's sort of the key language. But what Emily said, example is fine, right? Cutting off the heat might be an example. Turn off the AC in the summer in Houston might be a good example as well. Letting it be overrun by rodents might be an example. Water leakage might be an example because it's depriving them of the value of their property, the beneficial use. Emily, why is constructive eviction harder to prove than actual eviction, just in general?
I think that constructive eviction is harder to prove than actual eviction because you might have some difficulty. There might be some discrepancies or difficulties with the timeline, for example, and how long a particular condition is left uncured. So that makes it a little bit harder that way because a tenant might elect to stay in a place that's rendered uninhabitable, and the landlord might say, well, no, it wasn't a constructive eviction, you stayed there. So
okay, well, I thought you were going to be done, but you said something good. I want to ask you a follow-up question. In order for a constructive eviction to work, what must the tenant actually do?
The tenant must actually vacate the premises.
If the tenant sticks around, is that constructive eviction?
It is not.
Oh, very good. Excellent. Thank you, Emily. She answered 3 questions in one, so I get to save 2 more people on my roster. All right. With an actual eviction, right, you don't have to move out, right? Right. Let's say the landlord says you can't use the evidence room. That's an actual eviction. At that point, the tenant can withhold rent. But he does not have to move out, right? He can stay in the other parts of the property, but not move out. He can move out if he wishes, but he doesn't have to. But with constructive eviction, if you want to withhold rent, you have to move out. And you have to move out within a reasonable period, whatever that means, right? In other words, you can't claim the conditions are so awful and stay there. Okay? You have to actually move out. The act of removing yourself, the act of vacating, is proof that these are really awful conditions. Because look, I mean, if you're willing to sit through an apartment in the dead of winter, to use Emily's example, with that heat, then maybe it's not so bad for you, right? Maybe that's the best you can get. So it puts the tenant to a tough choice. They can move out and basically render themselves homeless, right? Hoping they can get some damages later. Or they can stay, in which case their constructive removal case fails. So it's a choice. With commercial, it's easier, right? You just find another property. With residential, it's a very hard choice for a person to make. Why? Because a court can come back later and say, oh, well, it wasn't that bad. You should have paid rent. And then the landlord prevails. So even if you move out, you may lose in court eventually. All right, so again, the key difference is with constructive eviction, you have to actually move out if you want to withhold rent. If you don't move out, you have to pay your rent. All right, again, so the 2 relevant dates here are in October. There was an actual eviction, at least of part of the property, when they said stop using it for evidence. And then by January, when they actually moved out, that would be the date of the constructive eviction because they left. They said too much, the way this last sewage leak and this and that. And they said, we're done. Questions so far? All right, Angelina, are you here?
Yes.
Angelina, what is this exclusive remedy clause in the lease? What is this about?
The exclusive remedy clause. So, I'm sorry.
Do you have it?
Let me borrow my notes. I do not.
All right, Alec, I'm running short on time. Alec, what's the exclusive remedy provision?
This provision essentially states that if the tenant feels this, like they were wronged in some way, all they can do is either file for injunctive relief or they can sue for damages, but they have no right to vacate the premises or something, right?
All right. So in this case, according to the appellate court, did the prosecutor have the right to vacate on his own under the lease?
Technically, no, but it didn't really matter, I guess.
Okay, good. Yeah, right. So the exclusive remedy provision barred withholding of rent, but why did it not matter here?
Because they were evicted.
And once you're evicted, does the lease matter anymore?
No.
Okay, that's exactly right. So just understand the two parts of this opinion, right? Part number one, the lease prevents the tenant from withholding rent. Generally, right? The lease prevents the tenant from withholding rent. If the tenant wasn't happy, the tenant could sue the landlord. Okay? But the second part is more important. Right? The second part is more important. Once the landlord evicted the tenant, the duty to pay rent dissolved. Right? Once the landlord evicted the tenant, the duty to pay rent dissolves. So once the duty to rent dissolves, there's no more unpaid rent that's to be paid. So it's actually a very straightforward case. I think the opinion is written in a far too complicated fashion, but there's exclusive rental provisions irrelevant. It doesn't matter because they were evicted. They were actually evicted and constructively evicted. So starting in January, there was no duty to pay the rent. Okay. Questions? All right. Any questions in this case? Yeah, Bradley, go ahead.
I have a question actually about the note, one of the notes afterwards.
Sure. Sure. Yeah. Which one?
Do we need to necessarily care about, for the partial evictions for actual and constructive, do we need to care about anything for that and knowing how that works?
I think so. Yeah. I mean, this is really a partial eviction case, at least the evidence locker, right? You know, if you have the lease for the entire premise and the landlord says you can only use part of it, that is a partial eviction. I think you should know about that. Yes, Natasha, go ahead.
If the rest of the building was fine and they said we'll just move to one part of it but reduce the rent, could that be a possible remedy? I
think you would need a new lease for that.
Okay.
And if the parties agree to a new lease and that's consensual, I think that's okay. Right. I mean, the landlord and tenant can always sign a new lease if things aren't working out, which reduces the rent. What happened here was the worst, where basically the landlord ignored the issue, said, oh yeah, everything's fine, and people are getting sick from the mold. And then the prosecutor's like, screw this, right? I mean, a general rule of thumb, if you're going to screw over a tenant, don't screw over the prosecutor, right? That's not the person you want to harm because they prosecute crimes, right? I mean, it seems like a really bad idea. The courts are never going to rule in favor of the landlord here. It was never going to happen. Zach, go ahead.
Would you happen to know how that exclusive remedy clause would impact a tort claim for these harms that are physically incurred?
Well, I suppose the prosecutor could have sued for the unsafe breathing conditions. Damages were permissible. They could sue for that, but they just couldn't withhold rent.
Okay, yeah, I mean, I can see how this is probably a crime. This guy seems like a neglectful, slumlord.
But it's actually not a slum. It's a beautiful building. I'll just bring up a picture of it. It's a gorgeous historic building in Indianapolis. So this is not a slum by any stretch. It was an old hotel or something. But definitely, I think the landlord was unable to stop the leaking, and he didn't really try. Here, I'll just show you a picture of this building. I mean, it's this gorgeous historical building in downtown Indianapolis. It's very, this is not a slum. We just look at it. It looks like Titanic or something, right? With the water.
It's a very nice building now that we see the pictures of it. But what I'm asking is that damages clause, that exclusive remedies clause clearly connects to damages connected to the physical community. But what about damages that occurred to the people when they got sick and had to get home? How would that clause, do you know if that clause would have any impact on their capacity to sue?
I think I think what probably happened, Zach, is that the employees would sue their employer, and in turn, the prosecutor would have to sue the landlord. Right? I don't think that there's privity between the employees and the building manager. I don't know that the employees can go after the building directly.
Okay, all right.
That's my tentative guess. Yeah, but it's a very, very pretty building in Indianapolis. Okay. Questions? Let's see. I'm right. I thought we'd have more time today. Okay, Catherine, go ahead.
I have a property question.
Sure. You're always a perfect place to ask it.
I don't understand how Torch plays into this. So for going back to like the very first question that you had, like the very first question. So for when you were talking about like the fair market value of the apartment and like the rent was $1,000, like the very first question that we had in class, if the tenant decided to not pay like at all and like the landlord couldn't cover, would the tenant be liable for the $1,000 or would they be liable for the fair market?
Yeah, really, I was waiting for someone to ask me that question. The facts here don't suggest the fair market value is higher than the actual rental value. So I think you just go with what the rental value is. If the landlord had put in evidence saying that the rent was below market, you would actually, I think, have to pay the market value. But yeah, I was waiting for that question all class. I'm glad I got it right at the very end. Good job. All right. Anything else? All right. That's all I have. I'll start the minute poll. Again, if you're interested in being my RA, email me the resume, the transcript, and the writing sample sometime next couple weeks. I'll have office hours today around 2:45. This is the last substantive class, but I'll see you again a week from today. Thank you very much.
Have a good weekend, sir.
Thank you. Hi, I emailed an order and I want to pay your information, please.